Welcome to another episode of Judge for Yourself. The courts appear to be increasingly becoming involved in a whole range of political matters. Opposition parties have been accused of politicizing the judicial system. While many may argue the courts may be the last arm of the state to ensure accountability from government, the fact of the matter is that there are a range of cases which come before the courts. The question is, are those appropriate for judicial adjudication? Are those not the matters of politics? Where do we draw the line? And what is the role of politics versus the courts in a country like South Africa, which has a very ambitious and comprehensive constitution? Now, if you wish to join this debate on Twitter, use the hashtag JFYCourts. To discuss these particular issues, we're joined by Helen Zille, leader of the Democratic Alliance and Premier of the Western Cape, Mathole Mosthekga, ANC MP and chairperson of the Justice Committee in Parliament, and Judith February from the Institute for Security Studies. Well, your party does go to court quite often.
Yes, we do, Dennis, because we believe...
Enthusiastic litigants.
Yes, we are, because we think that the Constitution needs interpretation and needs a body of case law to back it up. The Constitution insists on principles such as transparency, such as accountability, such as rationality, and we have to know what they mean in specific circumstances. So that is why we take cases to court. And then we get a body of case law, and the courts themselves, judges are very good at establishing doctrine to ensure that they don't cross the line. And we've had some very interesting cases in that regard. For example, the case that we took last year about the motion of no confidence in President Jacob Zuma, where the Constitutional Court said, we cannot tell Parliament when or how to establish a vote of no confidence, but we can say that they must have rules in order to do so, because that is a requirement of the Constitution. So those things are really important to establish, and then we have a body of case law, and in fact Parliament is not above the Constitution and can also be held by the courts accountable to the Constitution, and that is what we're doing.
But let's just take that case for a moment. It's a case I know well. Both at the High Court level and at the Constitutional Court level, the argument was raised, well, certainly at the High Court level, you've got to tell the Speaker to have a debate on the following day.
Yes.
That's ridiculous. You can't get courts to do that.
Well, the courts decided that they
I know they said they couldn't do that.
Yes, and we understand that.
Yeah.
We understand that entirely.
Weren't you overreaching?
Well, we weren't overreaching because we now have a very clear doctrine that Parliament must get rules for no confidence debates. And indeed, now they have rules for no confidence debates. So that was the outcome of that particular case. The courts say, no, we can't tell the Chief Whip or the Speaker how and when to organise no confidence debates, but they can't simply refuse to have them because there are no rules for them. Wow. They have to hold them and they have to make rules for them.
Dr. Mosthekga, do you think that courts are being drawn into issues that they shouldn't be, and if so, which are they?
I believe that courts are custodians of the Constitution and the constitutional values. But I don't believe that from time to time, people should be running to the courts, even where it is not justified to do so.
Could you give an example to me?
For instance, the DA and other opposition parties say to the Speaker of Parliament, schedule a motion of no confidence. He says, whether I do that or not depends on what the programming committee says. I have no powers. They insist that he has powers, or he must have powers, to frame a rule or to schedule contrary to the rules of Parliament. And they run to court.
And what they get out of the court, Premier, the Premier mentioned, Dr. Mosthekga, is that they don't get their primary relief, but they do get an order, as I understand, from the Constitutional Court, which essentially says there's got to be a rule which ultimately means that motions of no confidence can't be kicked into touch, that opposition parties have a right to have those heard, and obviously within reason. And that means that was a gain for them, sure.
The problem with that approach, and with what Premier Zille is saying now, is that they want to use now the courts to help MPs to understand the Constitution. That after every discussion they will run to the court because they want to establish precedents. Now Parliament has to deliver certain services to the public. Now the way the DA according to Premier Zille, wants to use Parliament, it means that Parliament is not going to achieve what its mandate is.
All right, can I ask you what you think?
Well, I think that sometimes, Dennis, part of this is about us not being able to resolve certain issues through the political process, and therefore there's certain times where we have to go to court, and the motion of no confidence was perhaps not the best example, but I would use, for example, the spy tapes issue, where the Democratic Alliance, Premier Zille's party, had to fight for years and years and years to actually get the spy tapes, when at the end it seemed as if there was no real reason for those tapes to be withheld, and we saw J. Kemp's dramatic concession at the end that he actually had no case to bring, that there was no reason for those tapes not to be made public.
Well,
so I think it's sometimes, it is
Sure.
about those in power, the elected representatives, in that case the president, dodging accountability. And I think we need to be very careful when we try to avoid political processes, because at the heart of a constitutional democracy is the issue of deliberation. When we lose the ability to deliberate about the little things and use the courts too much, I think that is a real problem.
Well, where do you think the courts have been used too much?
Well, I think that in the case of the issue around the motion of no confidence, I'm also looking perhaps ahead. I'm looking perhaps ahead at a constitutional court or other challenge with regard to the Public Protector's report on Nkandla, the primacy of that report, and also the primacy, I think, of other Chapter 9 institutions. Now, if we get to that point, I think that's the point where politics is broken down, where those in power want to dodge accountability and use the courts to, in fact, stymie the proper parliamentary processes.
I'll give you a chance. I'll give you both a chance, but I just want to probe this before I take a break and then give both. But what then do political parties do, or citizenry do, in circumstances whereby something doesn't happen in Parliament? You have no choice then, do you?
Absolutely. And Dennis, I'm not saying that the courts are not to be used. I think the courts are a final point of adjudication. That's the issue. And so, for example, we've seen virtually everything go to court. Again, I say the spy tapes, the Tlhadi Motsoeneng issue. We even had the chairperson of the SABC in this latest spat around her qualifications. Saying
National Director of Public Prosecution.
Correct. And saying that, I've got my advocate coming in, when this is a simple matter, but we become very litigious. And I believe some of those examples are not good ones to set.
Okay, I want to take a break, and then I want to give the other guests an opportunity to respond.